Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
Mr. Sinha argued that the trial court had in its judgment recorded that since Rajkumar fired a shot from rifle and his companions were armed with guns, therefore the witnesses got panicked and they never tried to know the truth that whether in reality the bullet of rifle ever hit Brahmapal or not. Stop. The best witness to state this reality could have been deceased himself, that whether the bullet fired by Rajkumar even hit him or not, or did he fell on the take just because he got panicked, since the bullet merely travelled from near his head. Stop. Since is dead, therefore in this situation there is no witness left to prove this fact, that whether the bullet fired by Rajkumar ever hit Brahmapal or not. Stop. Therefore, even in this situation where there is no injury mark of bullet rifle on the head of deceased, no effect is caused on the case of the prosecution, because under panic nobody is in this situation where he can access the reality. Stop. According to Mr. Sinha, this establishes that the conviction made by the trial court was only based on assumption, presumption. Stop. Mr. Sinha argued that all the prosecution witnesses, namely, had stated that as soon as the first shot was fired by Rajkumar Singh from his rifle towards, they all ran away with their back towards the accused, and they did not see who had fired but had nevertheless heard gunshots. Stop. Hence, none of the witnesses had deposed as to which of the accused was involved in firing apart from Rajkumar Singh. Stop. Mr. Sinha argued that the trial court erred in holding that the aforesaid material factors were minor contradictions and minor lapses on the part of the prosecution, and proceeded to convict all the accused persons guilty beyond doubt. Stop. Mr. Sinha argued that the trial court had completely ignored the chain of evidence to wrongly conclude that the accused persons were guilty, particularly the appellant. Stop. Mr. Sinha further argued that as per settled law, the doctrine of severability does not apply in the case of a statement of a witness in a criminal trial. Stop. Either the whole statement has to be discarded by declaring the witness hostile, or else the entire statement has to be relied upon. Stop. In this context, Mr. Sinha cited this court held that a statement that contains self-exculpatory matter cannot amount to a confession if the exculpatory statement is of some fact which, if true, would negative the offence alleged to be confessed. Stop. In this court held, it is settled law that an admission made by a person, whether amounting to a confession or not, cannot be split up and part of it used against him. Stop. An admission must be used either as a whole or not at all. Stop. if the statement of the accused is used as a whole, it completely demolishes the prosecution case, and if it is not used at all, then there remains no material on the record from which any inference stop.